go ahead, the floor is yours.
Thank you so much. Welcome, everybody. Jana and me will be presenting some thoughts and research results on the issue of immigration detention. We will be explaining in more detail what we are going to do in a minute. But to give you the framework in which this presentation is placed, Jana, could you please move forward to the first slide? So we will be going back and forth. Some parts will be presented by me, and then it goes on to Jana, and then back to me, and then back to Jana. Okay, to give you the framework of our research, I would like to connect it to the overall aim of the PROTECT project, and in particular to the particular contribution which the work package 2 is making to reaching this aim. We're looking at the interconnection between the Global Compact for Refugees or Migration, respectively, with the pre-existing legal framework in public international law. And more specifically, this pre-existing legal framework is formed by human rights law. A couple of human rights treaties in particular to which all EU member states are a party, or at least most EU member states are a party, and therefore a certain legal obligation on the part of the EU itself and its member states exists following from these human rights treaties. So one of the particular approaches of our work package is to ask ourselves, what is the contribution which actually the Global Compact for Migration, rather than the Global Compact on Refugees, is making in respect of refugees, in respect of persons seeking international protection. One of the issues which comes to mind is the legal position of asylum seekers, which is not specifically addressed in the Global Compact on Refugees, but rather there are quite some provisions in the Global Compact for Migration which may have an effect upon, or which applies to, asylum seekers. And one of these provisions which we find particularly interesting is objective number 23, which is reproduced here. So it calls upon the member states or the states commit themselves to use migration detention only as a measure of last resort and work toward alternatives. From a legal point of view, the principle of proportionality comes into mind when reading this particular provision. So a measure of last resort means, translated into legal language, that all other available measures have to be considered before this particular restrictive type of measure is used, namely using detention as a means of migration control, or here in particular as a means to control the movement of asylum seekers. And on the same note, the final words here, the commitment to work towards alternatives implies the same message. So states commit themselves to consider alternatives in order to reach the particular aims for which oftentimes immigration detention is used. What we are going to do now is to look into more detail into the provisions of human rights law that determine this particular principle of proportionality in the context of immigration detention. To guide this presentation, I would like to start with presenting two important conclusions to which we will be arriving, so you can follow it more easily. One particular conclusion is, surprisingly, that it's not the European Convention on Human Rights and its provision regarding immigration detention, but rather the International Covenant on Civil and Political Rights, a global treaty, which might be more interesting to look at when it comes to the legal obligations of the states in respect of immigration detention. One might usually expect that the regional European human rights framework may provide a higher level of protection, or at least the same level of protection as compared to the global level. But interestingly so, as we will show later on, in this particular case of immigration detention, this is not so. It's the International Covenant on Civil and Political Rights which provides a higher level of protection. That's the first important observation. The second important observation is that even measures which do not amount to detention in the narrow, legally technical sense of the word are constrained and governed by human rights law. We call these measures area-based restrictions. They have quite something in common with detention in the narrow sense, but for reasons which I will be explaining in more detail in a minute, from a legal point of view, they are not regarded as detention in the narrow sense. And we are observing a general trend that states and or the European Union seems to assume that restriction upon the liberty of movement of migrants more generally and of asylum seekers more specifically are well justified and, let's say, non-problematic once it is established that they do not amount to detention in the technical sense. But we found out, looking into more detail in the relevant provisions of human rights law, that also those area-based restrictions on the liberty of migrants that do not amount to detention are governed by provisions of human rights law that may render this particular area-based restriction unlawful under the existing human rights law framework. In the final step of our presentation, we will apply our overview of the existing legal framework under international law to the most recent proposals by the European Commission regarding detention of asylum seekers in the context of so-called border procedures. Okay, so therefore we will now move on to present the existing legal framework under the regarding detention, and then regarding area-based restriction, and then we will apply that to the most recent proposals of the European Commission. And at this point, I hand over the word to Jana.
Yeah, thanks, Jürgen. Yeah, so as Jürgen mentioned, we have an unusual situation in the context of immigration detention in terms of human rights law, because in Europe we're used to turning to the European Convention on Human Rights when in order to find out, you know, the human rights standard of a particular issue. However, the situation is slightly different with regards to the right to liberty and security. So the European Convention of Human Rights lays down the right to liberty in Article 5, and it says that everyone has the right to liberty and security of person, and that no one shall be deprived of his liberty save in the following cases. And then it has a list of cases where detention would then exceptionally be allowed. And one of those exceptions is named under F, the lawful arrest or detention of a person to prevent his effecting an unauthorized entry into the country, or a person against whom action is being taken with a view to deportation or extradition. what's notable here is that this provision does not have a general prohibition of arbitrariness. So other human rights law provisions on the right to liberty say that prohibit arbitrary detention in the broad sense. And among them, the first instrument that we have is the UDHR, the Universal Declaration on Human Rights, and that also had that general prohibition of arbitrariness. And then, but the reason why the European Convention does it differently is that they thought at the time, the drafters thought it would be better to have a more specific provision that clearly lays out the exact situations under, for which detention would then be acceptable. So the idea was that this would lead to a higher level of protection. The problem is then over time and in case law, the opposite has happened. So in particular, for the application of this paragraph 1F relating to migration, the European Court of Human Rights in Strasbourg has actually developed a case law that that essentially says you can detain migrants who have not who have just entered your country, were not allowed to enter, who entered irregularly, without that being necessary. So it's fine to detain people for bureaucratic convenience because we have this exception in the provision that says you're allowed to detain in order to prevent that someone enters unlawfully, right? So there is the first case that where the Strasbourg court established this is the Sadi case, Sadi versus UK. And then a line of case law has developed from there where essentially the European Court of Human Rights does not apply the proportionality requirement that Jürgen just outlined to the specific situation of immigration detention. Now, what does that mean for the EU? Because the European Convention on Human Rights has a special position in the EU legal order, and usually is the standard that the EU turns to. But that does not mean, that does not prevent or rule out that other sources of international law or EU law can provide higher protection. And that is, in fact, the situation that we have here. Because the right to liberty in other human rights instruments, and in particular in the International Covenant on Civil and Political Rights, is broader and has been understood to be and interpreted to be broader also in the migration context. So in the International Covenant on Civil and Political Rights, which is the, if you will, the global equivalent to the European Convention of Human Rights, it covers a similar set of issues. So that in Article 9 lays down that that everyone has the right to liberty and security of the person, and no one shall be subjected to arbitrary arrest or detention. And the committee, the Human Rights Committee, which is the body that is entrusted with ensuring or monitoring the implementation of this this treaty, has developed in its case law that, much unlike what the Strasbourg court argued, that indeed a proportionality assessment also applies to immigration detention. And that means that when we look at the case law and also the guidance notes of that body, that detention, even though it's not prohibited per se, it must always pursue a narrow and specific aim. It must be necessary and proportionate to reach that aim, and if a migrant is to be detained, that can only be because of reasons that are particular to that individual. So even though a brief initial period of detention is acceptable in order to document the entry of a migrant and record their claims, also to determine their identity if that is in doubt, further detention to process, for example, their asylum claims would be arbitrary if there is no particular reasons specific to the individual that justify such detention. And the two examples that the Human Rights Committee always mentions that would qualify as such individual criteria are a risk of absconding, so that the person would abscond if they were not detained, or that those persons pose risks against the national security. So we argue that this is in fact the relevant contents of the right to liberty that applies also in the context of the EU, and not the lower level of protection that's provided under the European Convention on Human Rights as interpreted by the Strasbourg Court. Yeah, and now I'll hand back to Jürgen, who will explain the next layer of protection.
Thank you, Jana. Okay, what Jana has just presented applies to detention defined as the deprivation of liberty as of a person. However, there are other restrictive measures, other imposition of legal obligations or other factual situations which are not regarded as detention in the legal sense as discussed a minute ago, but still are defined by the restriction of spatial movement of the persons concerned. So they have something in common, detention and this area-based restriction. They restrict the spatial movement of a particular person, but they do not amount to detention in the legal sense. Is there a categorical distinction? Is there something which is essential to detention and something which is essential to area-based restriction? The answer is no. Rather, what we take from the jurisprudence, both from the Human Rights Committee and the European Court of Human Rights, that this distinction between detention on the one hand and other restrictions of movement is a sliding scale. So it depends on all circumstances of the particular situation, the spatial arrangement, the legal obligations, the space of movement left for the person, or the particular sanction which will be applied when certain areas are left. All these factors of the particular situation will be taken into account in order to determine as to whether a particular measure is regarded as detention or not. What is immaterial is the denomination under national law. It's not relevant if the particular legislator or the particular administration calls it detention. To give you just one example, in a rather early case, the European Court of Human Rights has determined that keeping asylum seekers within the international zone of an international airport, the extraterritorial zone which is defined by the fact that persons who enter that space are not regarded having entered the territory of the state. So the transit zone of an international airport. If asylum seekers are kept within this extraterritorial zone, it is regarded as detention, although they are not detention centers in the narrow sense. And even the fact that the persons remain free to leave towards third states does not prevent this situation from being regarded as detention. So we have to look into particular situation in order to find out what is detention and what are our other area-based restrictions. But still, if it turns out that a measure does not amount to detention, that does not mean that human rights law does has nothing to say about that type of restrictions of liberty. And here, two particular provisions are most relevant. The first one you see here on the first slide, that is Article 2 of the 4th Protocol of the European Convention on Human Rights. And on the next slide, we will discuss Article 8 of the European Convention of Human Rights. There are similar provisions in the International Covenant on Civil and Political Rights, but in order to simplify things a little bit, we focus here only on the European Convention of Human Rights and its 4th protocol, since in this particular case, the jurisprudence is more, we can gain more information from the jurisprudence in the European context. Okay, so first, what is this 4th protocol? Well, it has been added to the original list of rights enshrined in the European Convention in an additional treaty. But the legal status of rights enshrined in such a protocol are exactly the same as rights which are enshrined in the original list. Since it's an independent treaty, there might be differences in which state have signed and ratified the particular protocol. In the case of protocol number 4 of the European Convention of Human Rights, it's noteworthy that only one member state of the European Union, which is Greece, has not ratified this protocol and therefore is not, under public international law, is not bound by this protocol. And there are other European states, such as Turkey, who also have not ratified this particular protocol. I get back to this point in a second. But generally speaking, we argue that the mere fact that only a single member state, namely Greece, has not ratified this protocol does not have the effect that the legal status under EU law is different from other provisions of the European Convention of Human Rights. We argue that the rights enshrined in protocol number 4 are mirrored also in EU law and also have the status of a fundamental right under EU law. If you want more information on the legal argument, how we arrived to this conclusion, I can answer that later on. But for the moment, I would like to base my talk on the premise that what is covered by protocol number 4 in terms of human rights is also part of EU law in terms of fundamental rights. Okay, let's have a look into this provision and how it is different from both the provisions which we discussed in respect of detention. Well, there are two main differences which amount to a lower level of protection as compared to detention in the narrow sense, but that does not mean there's no protection. Two elements stand out. The first one is you find in the first line here. So this particular provision applies to persons who are lawfully within the territory of the state. Or in other words, irregular migrants, persons who do not stay lawfully within the territory, are not covered ratione personae. So they are persons who cannot rely on this particular protocol. Accordingly, a legal debate arises. How do we identify who is covered by this provision and who is excluded by that provision? The European Court of Human Rights generally refers to the definition under national law. So it's therefore for the member states, for the states that have ratified that protocol, to define who is protected by this provision and who is not. However, there is much room for legal interpretation, and in the particular context of asylum seeker, the answer is not straightforward as to whether an asylum seeker is covered under in the European Union is covered by Article 2 of the 4th Protocol. One may argue, and some legal commentators actually do, that since the legal position is not yet determined, and in particular no positive decision on the need to international protection of that person has been made, this person is not yet lawfully staying within the territory. Others argue, in particular in the context of the European Union, asylum seekers do have a right to remain in the territory pending the decision on their asylum claim. This is explicitly stated in the current EU legislation, that as long as your asylum application has not been determined and an appeal procedure has not been concluded, you have the right to stay. And we would argue that under current EU law, this right to remain, as long as for the purposes of conducting the asylum procedure, brings asylum seeker in the European Union within the ambit of Article 2 of the 4th Protocol. But this is something one can legally debate about. This also, as an aside, might be one of the implications of the actual proposal from the Commission for amending the legal framework in asylum procedure, because according to the proposal from the Commission, it shall be explicitly stated that asylum seekers do not have the right to enter the territory. This is regarded as some kind of legal fiction, that they are actually present, they are physically present on the territory, but from the point of view of the law, they are not regarded as having entered the territory. That may have implications on as to whether Article 2 of Protocol number 4 is applicable or not. I've said there are two main differences. The one I've discussed now. The second one are the limitation clauses. As Jana has explained, detention may be lawful for particular purposes and with respect to particular additional criteria, including the principle of proportionality. And here is where the European Convention is different from the International Covenant on Civil and Political Rights. But any arbitrary detention is unlawful under public international law. This is somewhat different when it comes to other area-based restriction. It may actually be lawful to impose such restrictions for purposes listed in these limitation clauses, which you find here in paragraph 3 and 4 of Article 2. If you compare that with what is regarded as a lawful detention, you will see that the scope of the grounds for imposing that restriction is wider. As Jana has explained, the two most important grounds which the Human Rights Committee accepts in order to lawfully impose detention is the risk of absconding and the risk to security. The list mentioned in paragraph 3 here provides for a wider range of grounds for which such restriction may be possible, including maybe the most general clause, the maintenance of ordre public, of general interests of a particular nature. So it's a wider list of grounds which may justify that type of area-based restriction. But even that type of restriction must be necessary in a democratic society, and this formula necessary in a democratic society translate in the jurisprudence of the European Court of Human Rights into a fully fledged proportionality test. So also in this case, an individual decision would have to be made, and all circumstances of the case have to be taken into account, and it must that type of area-based restriction must constitute the least restrictive measure that is available in order to achieve the particular public interest mentioned here. One might even see in this paragraph 4 here that the list of grounds on which area-based restriction may be imposed is even wider, as it reads here that also restriction justified by the public interest may be permissible. Note that public interest is an even wider concept as compared to ordre public. But looking into the jurisprudence, the case law of the European Court of Human Rights, it turns out that paragraph 4, so this limitation clause enshrined therein, is not applicable to asylum seekers, since this fourth paragraph is defined by measures which apply to the population in general. One might conceive of area-based restriction in the context of the pandemic, but this wider concept of public interest is not sufficient to justify area-based restriction, particularly imposed on one group such as asylum seekers. In this context, the European legislator might have misread Protocol number 4, since in the existing EU law, area-based restriction on asylum seeker can also be imposed on mere public interest, and this particular provision may be unlawful according to the yardstick of Protocol number 4. Okay, so to sum up, in contrast to what is generally assumed, there is a human rights framework which applies to area-based restrictions which do not amount to detention. And as Jana will explain in a minute in more detail, the entire concept of the European Commission is based on the idea that as long as it is not detention, you can basically restrict the movement of asylum seeker as you find convenient for the purposes of asylum procedures. Okay. I now turn to another slide, which is yet an additional layer of protection, which is also enshrined in the European Convention of Human Rights. And this might particularly be particularly relevant to persons who are not regarded as staying lawfully in the territory. So irregular migrants and arguably also asylum seeker are not covered by Article 2, Protocol number 4. Does that mean there is a protection gap when it comes to area-based restrictions? This position is taken indeed in part of legal scholarship. So there's the argument there's a protection gap that pertains to all those who do not fall within the ambit of Protocol number 4. We, however, argue that an additional supplementary layer of protection follows from Article 8 of the European Convention of Human Rights. So how is the legal relationship between Article 8 and the Article 2 of the 4th Protocol? There we found interesting jurisprudence of the European Court of Human Rights, who actually has dealt with the situation of Turkey. You remember I told you Turkey is one of the states that has not ratified the 4th Protocol. But in this particular context, the European Court of Human Rights rushed to move on and said, well, okay, so Protocol number 4 does not apply to Turkey, but basically the same level of protection follows from Article 8 of the European Convention of Human Rights, which is part of the law that Turkey has ratified. What is the content of Article 8 in respect of area-based restrictions? The most interesting concept is the one which is called respect for private life. There's a whole body of jurisprudence of the European Court of Human Rights, which has been developed in the context of expulsion, something different from asylum law. But in this particular concept, the European Court of context, the European Court of Human Rights has developed the idea that the private life consists of all social ties which persons have developed at the place where they actually stay and where they live. So therefore, if you expel a person, you cut these social ties. So it has to be justified to do that. The same argument applies to area-based restrictions. If you confine a person to a particular space of movement, you restrict the development and the maintenance of social ties of that person. If a person is confined to a small Greek island, it's prevented from fully develop and maintain his or her private life, and therefore such measures constitute infringements upon Article 8, paragraph 1, and therefore has to be justified according to the yardstick of paragraph 2. So it's to make an interim summary, area-based restriction do constitute an infringement of Article 8 of the European Convention, and therefore need justification according to the yardstick laid out in this particular provision. If we compare this limitation clause of Article 8, paragraph 2 with the other ones we've discussed before, you see that the level of protection is even somewhat lower. Here, the same concepts appear as in Article 2 of the 4th protocol, but some concepts have been added, which give states a wider scope of possible restriction, in particular the notion of economic well-being of the country. Does not appear in the 4th protocol, but is part of Article 8, paragraph 2. It basically boils down to the requirement, so that's how we understand the jurisprudence of the European Court of Human Rights, that you have to have the right to an individual decision which takes into account all private and public interests involved, and there is a need for balancing according to the principle of proportionality. But yet again, the mere fact that it might be helpful for administrative purposes to detain persons and or to restrict their movement in itself does not justify such a measure. It has to be demonstrated that this measure is proportionate to the aims to be achieved, and therefore all circumstances of the individual case has to be taken into account. Okay. So to sum up, in the combination of Article 2 for the 4th protocol and Article 8 of the European Convention of Human Rights, add another layer of human rights protection to area-based restrictions, such as the confinement of persons to a small island in the Mediterranean or other type of restriction of the movement of asylum seekers, which do not constitute detention in the narrow sense. And with this, I hand over to Jana.
Yeah, that's right. So now that we've learned about the human rights standards that apply to both those situations that do amount detention, but also those that don't, it's interesting to take a closer look at what the European Commission came up with in terms of a proposal for the border procedure. It's highly complex, right? It's so complex. I remember from Elspeth Guild's, the expert forum organized by Elspeth Guild a week ago or so, someone from EASO said it's so complex that they should do a simulation in order to figure out whether it works, right? So I tried to simplify it sufficiently and fit it into this slide. So what the Commission proposes is, and it really turns on the red line here, it proposes to add what they call pre-entry phase that happens before a person is formally admitted and authorized to enter, right? So this entire distinction of lawfully or not present, that really makes the difference. And so the idea is that all migrants who arrive irregularly at the border are subject to a screening procedure. That's what it's called. That's a new element. That is to take no longer than 5 days. And it's for identification purposes and to figure out what kind of asylum procedure those people will be subject to. Now, the screening procedure is regulated in its own, I think it's a directive that says, and that does not, that essentially says whether or not member states find it necessary to detain people during that procedure is up to them. They have to regulate that in national law. Okay, like it's difficult to think of a situation or the possibility of doing this without at least restricting movement, so at least imposing area-based restrictions. Anyway, so from the screening procedure, it will be decided whether people will go on into the regular asylum procedure on the left, where that involves also being formally admitted into the territory, so authorized entry, or whether they will be subject to what is called an accelerated procedure. And there is a relatively long list of situations under which someone will be subject to or can be subjected to an accelerated procedure. Only in three of these situations, the accelerated procedure is mandatory and connected to a border procedure. And that is in cases where the migrants have misled the authorities at the screening procedure and presented, for example, false documents, where the individual is considered to present a danger to national security, and importantly, where the recognition rate of the country of origin, where that person comes from, so asylum recognition rate, is lower than 20%. So all these, in such cases, member states will, according to the proposal, be obliged to apply what's called the asylum border procedure. That asylum border procedure happens at the border or in proximity of the border, and can take a maximum of 12 weeks, and people are to be kept in those locations at the border. That's the language in the proposal. There is no direct provision that says they may also detain, but there are provisions that say in those cases where the person is detained, and then there is a reference to the possibility to detain under the Reception Conditions Directive in Article 8. So, so it's a bit of an unclear, fuzzy language. It's clear that member states will have to manage to keep those people there. That will, in any case, require area-based restrictions, and in many cases, likely amount to detention. And then the outcome of the asylum border procedure can either be well, recognition, then they're let in. That should be an extra arrow. Or if they exceed the 12 weeks that are allowed for the asylum procedure, then those persons will also have to be allowed to enter the territory and will sort of proceed into the regular asylum procedure to decide on their case there. Or if it's managed during those 12 weeks to actually come to a decision, a final decision, including appeals, then they will move into a return border procedure. So also still not allowed to enter the territory. And that return border procedure, in turn, can also take a maximum of 12 weeks. So we will have a total of half a year that people could be kept at the border. Again, same language. During that procedure, migrants are to be kept in locations at the border. But then there is an interesting further detail where they propose that in case where migrants had been detained during the asylum procedure, so where member states had opted for detention during the asylum border procedure, then those migrants who then enter the return border procedure, they can be further detained in order to, I suppose, continue to prevent unauthorized entry. So there they have this very broad basis for that further detention that even in terms of the terminology used reflects Article 5 of the European Convention on Human Rights. Interestingly, if they had not been detained during the asylum border procedure, that doesn't apply. In those cases, then those who are then subject to the return border procedure can only be detained on the grounds that the return directive lays out, and that is restricted EPR. So only if there is an individualized risk of absconding or hampering the asylum procedure, which, yeah. So, and then the idea is that they would return. What the proposal doesn't exactly say very explicitly, and that's why this is a bit of a lighter gray, is what happens if return isn't effectuated, what happens if it doesn't work, that they are actually returned after those 12 weeks. Likely they would then be, by default, because the procedure can only take 12 weeks, would then be transferred into the regular return procedure. And that would then mean authorized entry as well. Yeah, so we see here that what it looks like when you read the proposal is really that the Commission tiptoes around the obligations from human rights law and tries still to implement a relatively restrictive system that's, on the whole, however, very confusing and complex, and will likely involve detention and area-based restrictions that are not in line with the standards that we have just outlined. Jürgen, would you like to add anything?
No, just perfect. We can shortly explain the context from which our research has emerged on the last slide.
Oh yeah, that's right. We do have a last slide.
Yes.
Yeah. Do you want to do that?
Yeah, I can do. So we have been working on the issue of human rights challenges to European migration policy for quite a while. In a Gießen-based team, which consists of Jana, Frederik von Habu, and me, and we have published a study which we recommend to your further reading, where you find the references to which we had referred here rather generally. And it also covers certain other issues which we find the most pressing human rights challenges to European migration law. You will find the references and you can download it on the page mentioned here. And we heavily rely on this preliminary research, which has emerged in the context of another project, on our further work in the PROTECT context. So we will be more systematically look into those aspects where the human rights framework is particularly relevant for asylum seekers and or refugee in the broad sense, and where the Global Compact for Migration seems to strengthen the human rights commitments of the states. That might be a surprising observation, starting with what we have presented to you here, that the language of a general requirement of a principle of proportionality has found its way in the Global Compact for Migration, although it is not part of the settled case law of the European Court of Human Rights. And therefore, there might even be some kind of future interplay where the Global Compact for Migration might be referred to as an additional argument in order to further develop and and at some point even change the jurisprudence of the European Court of Human Rights. Well, that was it from my side. Would you like to add something, Jana?
No, thanks, Jürgen. That was perfect. I'm happy to start with discussion.
Okay, so we're happy to discuss our findings with you.
Perfect, Jürgen and Jana. Thank you